Government's reply in support of its motion for continuance and proposed revised scheduling order. United States of America plaintiff versus Donald J. Trump and Waltine Nada defendants. The United States files this reply in support of its motion for continuance and proposed revised scheduling order ECF number 34, MOT. In their response, in opposition to the motion ECF number 66, RESP, defendants Trump and Nada claim unequivocally that they cannot receive a fair trial prior to the conclusion of the presidential election, urge the court to withdraw the current scheduling order ECF number 28 and request the court not even consider a new trial date until some unspecified later time, RESP at 9 and 10. There is no basis in law for proceeding in such an indeterminate and open-ended fashion. The defendants provide none. For the reasons discussed below and in the government's motion, the court should reset trial date in this action for December 11th, 2023. Applicable legal principles. Any discussion of setting trial date must begin with the Speedy Trial Act of 1974, 18 U.S.C. 3161-3174, the Act. The very first sentence of the Act forecloses defendant's proposal here. In any case involving a defendant charged with an offense, the appropriate judicial officer, at the earliest practicable time, shall, after consultation with the counsel for the defendant and the attorney for the government, set the case for trial on a day so as to assure a speedy trial. USC 3161, the defendants chide the government for seeking an expedited trial, RESP at 1, 2, and 8, but in doing so, they have exactly backward. A speedy trial is foundational. A speedy trial is a foundational requirement of the Constitution and the United States, not a government preference that must be justified. See U.S. Const. Amend 6, 18 U.S.C. Chap 208, captioned Speedy Trial. The Act's manifest purpose is ensuring speedy trials. Bloat v. United States 559 U.S. 196 210 2010. Any deviation from its 70-day benchmark must be justified. To be sure, the Act authorizes a court to exclude certain periods of delay from the speedy trial calculation, including any period of delay resulting from a continuance granted. On the basis of an end of justice finding, 18 U.S.C. 3161 H7A, but because the Act was designed with the public interest firmly in mind, in order to exclude such delay, a district court must find that the ends of justice served outweigh the best interest of the public and the defendant in a speedy trial. Zedner v. United States 547 U.S. 48 9501 206. The public interest cannot be served. The Act recognizes if defendants may opt out of the Act entirely, i.d., which the defendants effectively tried to do here by requesting an indefinite adjournment of the trial for a minimum of some 15 months. See Barker v. Wingo, 407 U.S. 514 519 1972, noting the social interest in providing a speedy trial, which exists separate from and at times in opposition to the interest of the accused. Defendants' base for urging the court to defer setting trial date boils down to alleged significant issues of first impression. 2. The volume of discovery. 3. The pendent CIPA process. 4. Possibility that their dispositive motions might succeed. 5. The alleged inability to select an impartial jury for trial. And 6. Their own schedules, those of their lawyers. None of these warrant a wide open schedule the defendants urge the court to adopt. 2. Defendants' pro-offered legal issues are not novel. Defendants cite two alleged novel legal issues they claim make this case complex under 18 U.S.C. 3161H7B2. The authority of special counsel to bring and maintain this action and the alleged intersection of the Presidential Records Act, PRA, with the criminal statute charge in the indictments, RESP at 2, 7, and 8, the former is hardly an issue of first impression. The United States versus Nixon, in the United States versus Nixon 418 U.S. 683 694 1974, the Supreme Court ruled that Congress gave the Attorney General the power to appoint special counsels, and in Re Grand Jury 916 F3D 1047 and 1052-54 D.C. Circa 2019, the D.C. Circuit Court held that special counsel appointed by the Attorney General has the authority to investigate and prosecute federal crimes. As for the impact of the Presidential Records Act on this prosecution, any argument that it mandates dismissal of the indictment or forms a defense to the charges here borders on frivolous. The PRA is not a criminal statute and in no way purports to address the retention of national security information. The defendants are, of course, free to make whatever arguments they like for dismissal of an indictment, and the government will respond promptly. But they should not be permitted to gesture at a baseless legal argument, call it novel, and then claim that the court will require an indefinite continuance in order to resolve it. Moreover, even the courts were to conclude these legal issues were novel. The act requires more. The issue must be novel, such as it is unreasonable to expect adequate preparation for pretrial proceedings, or for the trial itself within the time limits established by this section, 18 U.S.C. 3161 H7B2, defendants make no showing whatsoever on this score. No extensive review of discovery or classified information but would be required to prepare briefs on these subjects. As with any pretrial dispositive motion, all that is necessary is the indictment, which the defendants had for over a month. And in fact, Trump, including his current counsel, has already briefed in this court a variation of this argument. See example number 22 CV 81294, Canon ECF number 171, filed November 8th, 22. The legal issue defendants raise do not justify deviation from a speedy trial date, much less open-ended deferral of considering one. 3. Discovery does not warrant continuance. The defendant's claim regarding the volume of discovery do not support continuing the trial date beyond December 2023. Rather, the thorough and organized discovery the government has provided and will continue to provide in the near term is entirely consistent with the trial date. In arguing otherwise, the defendants have failed to include the important information about the government's discovery productions, including the steps the government has taken to make the defendants' review as efficient as possible. For example, government's production included a set of key documents referenced in the indictment or otherwise determined by the government to be pertinent to the case. See ECF number 30 at 2. In addition, defendants' convenience, the government included with the first production of discovery log, which denotes by Bates' range of source of material. Although the government production included over 800,000 pages, the set of key documents was only about 4,500 pages. The government similarly identified to the defendants a small subset of key CCTV footage referenced in the indictment or otherwise pertinent to the case, CID. And although the CCTV footage the government obtained and produced comes from various months, the defendant's characterization of the production as including 9 months of CCTV footage. See RSP at number 4 is misleading. The government obtained footage only from selected cameras, many of which do not continuously record, from selected dates through the period for which it obtained footage. Defendants' alleged inability to use contract personnel to assist in unclassified documents review is puzzling. They claim the reason is that all the discovery materials are sensitive and high profile. Our response at number 5. But discovery materials are sensitive in a criminal case, and courts routinely enter protective orders covering defense document reviews. Magistrate Judge Reinhardt entered such an order here with no opposition from the defendants, ECF number 27. The order specifically authorizes disclosure to persons employed to assist in the defense, ID at number 2, and defendants offered no explanation of why they could not engage in such personnel here. The defendants also rely on the government statement in its discovery letter that there will be additional productions of discovery related to some devices and search warrant returns. And note that the government has not produced all interview-related materials, including certain witness statements and associated memorialization of those statements. Response at defendants 4 omit representation in the government's discovery letter about the timing of discovery. That has been and will be provided. The government has informed the defense that it intends to disclose promptly all witness statements and associated memorialization of those statements, even if they would not be discoverable under 18 U.S.C. 3500. To that end, government has already produced all unclassified witness statements and the associated memorialization of those statements for interviews that occurred prior to May 12, 2023, and transcripts of all grand jury testimony from the District of Columbia and the Southern District of Florida through the present. See ECF number 30 at 1. In the next week, the government will produce unclassified witnesses' statements and associated memorialization for interviews conducted between May 12, 2023 and June 23, 2023. The government has made these productions promptly following the arraignment despite having no obligation to do so. See ECF number 28 at number 4, obligating the government to turn over Jenks Act material no later than the morning of the first day of trial. With respect to the devices and search warrants returned, the government has produced all applications for search warrants and the warrants themselves in order to facilitate the defense's ability to file pretrial motion. The government has also produced all relevant contents from devices, if obtained, except for 3 devices that were produced voluntarily, the relevant content of which will be produced in the next week, and 2 of defendant Nada's devices. For defendant Nada devices, the government has already produced much of the responsive filtered scoped content based on the government's earlier view of the device, content in different form. In short, the government has promptly produced thorough discovery and in an organized manner to include early production of the Jenks Act material. It also bears emphasis that government has already sought nearly 4 months continuance of trial, in part because of the need for both sides to review and process discovery. Mott at 3. There is no discovery-related reason for further delay. The jury selection in this case beyond December 2023. 4. Classified information procedures do not justify continuance. Defendants further argue that an indefinite continuance is necessary because they lack classified discovery and because they contend the necessary procedures under CIPA are inherently complex. Respect to at 4 and 7. With respect to the first argument, the government was prepared to make its first tranche of classified discovery available July 10th, contingent upon defense counsel having obtained interim clearance, ECF number 34. Exhibit B. However, in order to receive an interim clearance, counsel first needed to submit their form SF-86 and supporting documentation to the Litigation Security Group. ECF number 34, Exhibit A, 4. As of this filing, only 2 counsel of record have completed this task. The court has set a deadline of today for them to do so, ECF number 57. In the course of its investigation, the government obtained approximately 340 documents bearing classification markings that had been moved from the White House to Mar-a-Lago at the end of President Trump's term. See generally in indictment ECF number 3. The government's first tranche of classified discovery will include all documents with classification markings recovered from Mar-a-Lago to which counsel's interim clearance will permit them access. This represents a large majority of the classified records from Mar-a-Lago. The government also plans to produce a small number of witness statements and memorialization of those statements that contain classified information. The government intends to transport these materials early next week to the Sensitive Compartmental Information Facility, SCIF, maintained for all cleared defense attorneys at the C. Clyde Akins Courthouse in Miami. Once defense counsel have their final clearance, the government will bring the remaining Mar-a-Lago documents to the SCIF in Miami, as well as other materials, including Jenks material and classified records pertaining to the declassification of various materials during the Trump administration. In sum, neither the amount of classified discovery in this case nor the timetable for its production is a reason for an indefinite continuance of a trial date. The need of CIPA proceedings is also not justification for a period of uncertain delay. The government's proposed CIPA schedule, Exhibit B to ECF number 34, remain viable, even with the delay caused by counsel's late submission of their SF-86 form. Counsel will have almost 2 months to review the initial production of classified discovery before having to file any notices under CIPA Section 5. The 2 cases defendants reference as examples involving CIPA that had trial dates further from arraignments do not support their position. In response, at 7, United States v. Winter, number 1:7 CR 34 SDGA, following a planning conference during which classified discovery issued were discussed, the court initially set trial for October 23, 2017, less than 5 months after June 2017 arrest and arraignment. CSDGA ECF number 33. Not until the Fifth Amendment scheduling order was the trial date reset to October 15, 2018, CSDGA ECF number 204, following case-specific circumstances requiring adjustments to the schedule. In United States v. Joaquin, number 18 CR 611 ND, Illinois, some of the delay was due to COVID-19 postponements during the pandemic. CND, Illinois ECF numbers 87, 88, 98, and 103. Moreover, CIPA was not central to the delay. In fact, there were no proceedings under CIPA, Section 5 or 6, and CIPA had little or no influence on how long it took the case to reach trial. By contrast, United States v. Mallory, number 1:17 CR 157 ED, Virginia, an espionage prosecution of former CIA agent who spied for China that involved CIPA proceedings, including under CIPA Section 4, 5, and 6, less than a year elapsed between arrest and verdict. And in United States v. Hoffman, 212 CR 184 EDVA, an espionage prosecution of former sailor who sought to spy for Russia. The case went from arrest to verdict in less than 9 months. There's no reason to believe that CPIA proceedings in this court would be any less efficient. 5. Defendants' remaining arguments are meritless. Defendants' remaining arguments similarly provide no basis for deferring setting a trial date. First, the prospects of the motions might be fully dispositive. Response at number 2. In no such basis, and it is not a factor under the Speedy Trial Act for the court to consider in deciding whether to grant a continuance. The defendants cite no case for their proposition, which is unsurprising because, again, they have it backwards. The Speedy Trial Act requires the court to set a trial date, and the federal rules of criminal procedure key the filings of pretrial motions, including dispositive motions under Rule 12, relative to the trial date, see 18 U.S.C. 3161, Fed R. Crim P. 12b3, and C. Defendants would have it the other way around, requiring courts assess the likelihood of pretrial motion success before the motion is even filed, in order to determine whether to set a trial date. This argument provides no support for defendants' requests to postpone trial indefinitely. Similarly, defendants claim that the court could not select an impartial jury until after the presidential election does not justify further delay here. Response at number 9. First and most importantly, there's no reason to credit the claim. Our jury system relies on the court's authority to craft a thorough and effective jury selection process on prospective jurors' ability and willingness to decide cases based on evidence presented to them, guided by legal instructions from the court. To be sure, the government readily acknowledges that jury selection here may merit additional protocols, such as a questionnaire, and may be more time-consuming than other cases, but those are reasons to start the process sooner than later. The only 2 cases defendants cite on this subject do not help them. See response at 9. Both stand for a familiar proposition that in the wake of a particularly heinous and vicious crime that inflames the sentiment of the community, courts cannot continue a trial or transfer it. The first case, Coleman v. Kemp, involves brutal murders, including one victim who was raped multiple times prior to her murder. 778 F2D 148 1488, 11th Circuit, 1985. The 11th Circuit concluded that because of the inflammatory, prejudicial pretrial publicity that so pervaded the specific community where the cases was tried, ID at 1540, the case required a change of venue, CID at 1538. Similarly, Shepard v. Maxwell involved the petitioner's pregnant wife being bludgeoned to death in the upstairs bedroom of their Lakeshore home, 384 U.S. 333, 335 to 36, 1966, to state the obvious. The concerns that justified continuing or transferring a trial involving vicious murder, repeated rape, or a child victim do not justify an indefinite, protracted continuance of this trial during the pendency of a presidential election cycle. Moreover, the conditions that defendants argue will make it a challenge to select a jury will not appreciably change after the completion of the election. The government's position is that the best way to move this case forward, consistent with the defendant's rights and the public interest, is to set a trial date now, with interim deadlines for CIPA, procedures, and motion in praxis leading up to that date. Finally, the defendant's professional schedules do not provide a basis to delay trial in this case. Many indicted defendants have demanding jobs that require a considerable amount of their time and energy, or a significant amount of travel. The Speedy Trial Act contemplates no such factor as a basis of continuance, and the court should not indulge it here. The defendants also contend that the counsel's trial schedule make it nearly impossible to prepare for this trial by December 23rd, RESP at 10. but nothing about defense counsel's trial schedule justifies extraordinary continuance they seek. And in any event, it takes more than counsel's claim of a crowded schedule to carry the burden of justifying a continuance, since a court schedule should not be subordinate to the schedule of the lawyers that appear before it. United States v. Handharted, 156, F. Sup. 2-Day 988-999, ND, Illinois, 2001. United States v. DeCastro Font, 583, F. Sup. 2D 243-246, DPR 2008. This court deems defense counsel's pretrial existing trial schedule insufficient justification for granting a continuance in this case. For all these reasons, the court should reject defendant's invitation to defer consideration of a trial date and should set jury selection to begin December 11th, 2023. Respectfully submitted, Jack Smith, Special Counsel, J.I. Brett, Julia A. Edelstein. Once again, thank you all for listening to this reading. I cannot get over how well written and thought out these documents are as I read them out loud. And if you enjoy this content, please, I ask that you like and subscribe, because there's a lot more coming. And frankly, it's good stuff. My name is Terrell Hussain. This is No Opinion. Please feel free to add your comments and opinions below. Thank you again for watching.